Welcome to our YouTube video series on business incorporation and the law. My name is Christopher Neufeld of Neufeld Legal, and in this particular video we will be discussing the concept of the Unlimited Liability Corporation, or ULC. So you heard me right on this. It's an unlimited liability. So what is this? Well, it is a Canadian corporate designation for a specific type of company that's only available in Canada, and more particularly in 3 provinces, that being Alberta, British Columbia, and Nova Scotia. And this unlimited liability company enables the shareholders to be liable for unlimited amounts of any liability, act, or default of the corporation. So why exactly would somebody want to have this kind of unlimited liability? Well, the purpose of this unlimited liability is such that an American corporation can tax plan and utilize a ULC in Canada to gain the benefits of a flow-through entity status for American tax purposes while maintaining a corporation for Canadian tax purposes. So that is the rationale behind this. So when a U.S. company is investing in Canada through a corporate acquisition of Canadian corporate entities and or Canadian corporate assets, especially where those assets or operations are expected to generate a loss, strategically they may look to utilize an unlimited liability corporation that is created for that specific purpose. So what happens in that situation? Well, when they're filing their taxes in the United States, the entity, the ULC, is disregarded as a flow-through entity under the U.S. check-the-box system, thereby permitting the pass-through of U.S. federal tax treatment of a proprietorship or a partnership. Meanwhile, on the Canadian tax side, the ULC remains a taxable Canadian corporation for purposes of the Income Tax Act. Now, how the mechanics of this tax treatment works on both sides of the border and how it interacts with the tax treaty between the United States and Canada is all subject to strategic planning and interpretation of the relevant tax laws and the relevant tax treaty. So in that respect, there are opportunities available. Those opportunities might well be modified by interpretations by either the Internal Revenue Service or the Canadian Revenue Agency, such that it's always advisable to plan these strategies with knowledgeable tax and legal counsel. And considerations need to be made with respect to the particular jurisdiction from which the ULC is going to operate, given that there are differences between these various ULCs on a technical basis, wherein in Alberta, the shareholders of the ULC are liable for all the debts and liabilities of the corporation at any time, whereas in British Columbia and Nova Scotia, it is on the liquidation shortfall that the shareholders become liable. Nonetheless, there is a lot that goes into the planning, and it can be a very advantageous, when correctly implemented, strategic plan to interpose a unlimited liability company into an American transaction that seeks to acquire Canadian assets or Canadian corporate entities. I trust you found this YouTube video beneficial, providing you some scope as to the purpose and the rationale for the Unlimited Liability Company, or ULC, in Canada. And if you have legal matters and tax matters of a legal nature, transactional, pertaining to ULCs or this type of transaction, please do not hesitate to contact us. Thank you.